And now to a decades-old Newaygo County murder case. Yesterday, we reported the man convicted will receive a new sentence.
13 on your side's Callie Lichter looked deeper into the appeal that got him to this point and the original hearing behind it. She joins us now with what she found.
Elena, Juliet, a judge agreed Roy Snell did not receive effective counsel during an original case hearing. A 61-year-old man will get a new sentence after the Court of Appeals agreed with his claim that his counsel was ineffective during a hearing granted to juvenile offenders. Roy Snell was convicted of felony murder and felony firearm in the 1983 Newaygo County murder of Richard Atwood. He was arrested in Minnesota in 2020 and tried and convicted in Newaygo County in 2022. Although Snell was in his late 50s at the time of the sentencing 3 years ago, he was 18 at the time of the crime, granting him a Miller hearing after multiple court cases set precedent that life without the possibility of parole for juveniles 18 and under is cruel and unusual punishment. A Miller hearing is an evidentiary hearing which decides if a juvenile offender should be sentenced to life without the possibility of parole or a number of years based on mitigating factors. He was still sentenced to life without the possibility of parole for the capital offense, but Snell didn't appeal the fact that he had a Miller hearing. He claims that his attorney at the time didn't do all she could to grant him an effective case. During his original Miller hearing, he claims, and the Michigan Court of Appeals agrees, that his original attorney did not hire an adequately prepared mitigation expert. That expert would build a case based on the 5 Miller factors that have to be considered before a juvenile is sentenced to LWOP. The expert that testified at the hearing was different than the one the defense hired, and although a part of the same firm, could not answer questions because she did not have sufficient time to review records. A new expert hired by Snell's new counsel found evidence that would be relevant to the hearing, and the Court of Appeals believes that there is reasonable probability of a different outcome if all was prepared effectively. The court threw out his sentences based on this claim, sending it back to the Newaygo Circuit Court for a new Miller hearing and resentencing. They did uphold his conviction. A new Miller hearing has not been set in Newaygo Circuit Court. Elena and Juliet.